Hi, if you're here, that means you probably have some questions on whether you should do a will or a revocable living trust for your estate plan. Hi, I'm Chuck Roulette. I'm a nationally recognized attorney, author, and speaker. I'm licensed to practice law in Florida as well as in Minnesota. And over the last few years, I have taught over 25,000 fellow attorneys, CPAs, and financial advisors across the country advanced estate, asset protection, and elder law planning strategies. I've also been interviewed on local and national media and am the author of several books. And whether I'm teaching a class or I'm being interviewed or I'm working with a private client, a common question I get is, well, should I do a will or should I do a trust? And I tell all of my clients, it's personal preference. Both of them get you to the same destination point. It's just how you get there. So the first thing to be aware of is if you didn't have a plan in place at all, your family's going to have to go through the process of probate. And that's basically going to court and getting the legal authority to sign the paperwork that's required to transfer ownership of your assets. So whether that's selling a piece of real estate, closing a checking, savings, life insurance account, it's basically the court giving signature power to the personal rep or the executor. And if you have no plan in place, the court follows state law to figure out who the personal rep or the executor is and where it's all going, which may or may not be where you would have wanted it to go. If you do a will does not avoid probate. In fact, that's probably one of the biggest misconceptions we see in the general public. They think, well, the whole point of doing a will is to avoid probate. And that's not the case at all. In fact, a will is a set of written instructions to the probate court on how you want probate to occur. In fact, there's sort of a saying in estate planning circles, where there's a will, there's a probate. So what a will does is it gives written instructions to the court on how you want probate to occur. So they're following the instructions in your will versus state law. And you pick up two significant advantages. You get to decide who the personal rep or the executor is because you're nominating them in the will. Then you get to decide where everything is going. And here's a third sort of hidden benefit when you do a well-designed will. You can also place protections or restrictions on receipt of those assets. So those are huge advantages over doing nothing and letting the court make all of those decisions. But a will does go through probate. Now, a revocable living trust. Probably the second biggest misunderstanding I see in the general public is they think trusts are only for the ultra rich. I get clients in my office all the time that tell me, well, I'm not Warren Buffett, I'm not Mark Zuckerberg, I don't need a trust. Sort of the wrong way to think about it. A trust is fundamentally a probate avoidance mechanism. So without going into all the details, you're basically using the trust to transfer signature power over your assets to someone of your choosing so that they don't have to go through probate. So again, I tell my clients which one you choose is between the will or the trust is personal preference. They're both documents that say, hey, if something happens to me, here's who I want in charge, here's where I want it going, here's how I want it getting there, any protections or restrictions I want to place on receipt of those assets. They're just different ways to get there. The will requires the probate court to get involved, whereas a fully funded revocable living trust does not. So sort of the pros and cons are, wills tend to be less expensive up front. There's less legal work involved in setting them up, but they tend to be more expensive and cumbersome on the back end because your family has to get a probate court involved. With a will, you sign it, you're done. For the trust to work, there's a process of funding the trust, which is changing the ownership or beneficiary designations on your assets. Now, when you work with us, we take care of some of that for you, and then we'll give you written instructions on how to do the rest, but it's a bit more homework for you. The will goes through probate, the trust does not. So that's kind of an overview broadly of the pros and cons of the two, and what you pick is entirely a matter of personal preference. Now, having said that, we're finding that the vast majority of our clients are choosing to go with revocable living trusts because they tend to be a little more easy and inexpensive for the family, and because you're avoiding probate, it's keeping things private. And in fact, in 2014, AARP did a study and they were looking at probate costs nationwide. And one of the interesting things in that study is they said about 75 to 80% of people are now choosing a revocable living trust versus a will. So again, which one you choose? Personal preference. They both get you to the same destination point, which is this is who is in charge, this is where I want it going, protections, restrictions. It's just the will requires probate, the trust does not. So I hope you found this helpful, and be well.